Today is Monday, November 11th, 2019, Veterans Day here in Des Moines with about 3 inches of snow on the ground. We're here today with Mike Streit, who for 27 years served in the Iowa Judiciary, first in 1983 through 1996 as a district court judge, and in 1996 he was appointed by Governor Branstad to the Iowa Court of Appeals, where he served until 2001, when he was appointed to the Iowa Supreme Court by Governor Vilsack. During that time, he wrote over 600 opinions as an appellate court judge and 112 opinions on the Iowa Supreme Court. Welcome today, Mike, and we're glad to have you here, and love to talk about your involvement with the courts and just who you are and how you got there.
Thank you for having me.
Can you tell us a little bit then about growing up? I think it was in Sheldon, Iowa, is that right?
Yes, I grew up in Sheldon, Iowa. I was born on a farm just east of Sheldon, Iowa, and only lived there for a couple of years, and my dad finally moved to town. He had been a tenant farmer and decided to sell oil and heavy lubricants to farmers as opposed to being a farmer himself. Also, he was the manager of the airport and taught hundreds and hundreds of people how to fly. For years after I left Sheldon, I'd run into people that told me, "Your dad taught me how to fly." So I grew up in a flying family. We didn't belong to the golf course, we belonged to the airport, and which means we flew and grew up and everything about airplanes. And he taught me how to fly, only I decided not to solo or pursue that because of it just didn't interest me enough to go that far.
And brothers and sisters?
I have a couple brothers. One's out in Rhode Island and deals with energy products, and one's in banking and finance up in Fort Dodge, Iowa. I have a sister up in Austin, Minnesota, and she also lives in Palm Springs.
Wow. And you were educated, I think, in parochial schools?
Yes, I went to St. Patrick's grade school. I started in first grade there. Was the first class when they opened up the school, and at 8th grade switched to the public school, which was quite a rude transition. For 8 years had been pounded in our heads. Before we ever spoke in class, we'd stand up and address any question, anything that was asked of a student in that type of parochial school back then. You'd stand to speak, and it took years to break you of that habit, to the tittering of all the non-Catholics in the public high school.
Well, you had to relearn it as a lawyer then?
Yeah. And usually by about 2 years you'd quit doing it, but every now and then just your reflex would make you stand up to answer a question from a teacher, and everybody, they'd all know this kid's from the parochial school, from the Catholic school.
So you would have graduated from Sheldon High School?
Sheldon High.
And what year was that?
Well, that would have been 1968.
68. And then were there any particular influences on you in your education up to that point?
Nothing in particular other than a general education. I decided I was slanting myself more towards writing and the law. I found that I was not particularly suited for science and chemistry, even though I did take a chemistry course as an elective in undergraduate at the University of Iowa, and I finally figured out that everybody in that course was pre-med. So I went more the writing and political science and economics, which was an eventual major.
And then, how did this Iowa boy end up going to law school in California at the University of San Diego?
Well, I had been accepted to all the traditional Midwestern schools, and times have changed so much from what they were back then. Today, and I have a son that actually is attending the University of San Diego too right now as an undergraduate. I had never been to California, and I thought that was a good enough reason to go to California as any. Even though I'd have been accepted to the Midwestern schools, I just thought it'd be a great adventure to go to California school, so that's what I did. Drove out sight unseen and drove through what I call La Jolla when I went through it.
La Jolla?
It's called La Jolla.
It's a private school, and that meant tuition would have been higher than, let's say, the University of Iowa Law School at the time. How did you were you able to finance or afford this place?
It took a lot of dexterity. I saved every penny I had. The summer before my first year, I worked for the Des Moines Planning Commission as a planning intern. Saved every cent, every cent. Had one hamburger a week. Ate sweet corn all summer long because sweet corn you could buy for 25 cents for a half dozen. And then once a week I'd have a hamburger. Saved all that money, and back then tuition was about $5,000, where the University of Iowa's tuition I think was about $1,800 for a year of school. So it was quite a shock to spend that much for education. My second year and going into my third year, I got a half tuition scholarship for editing the school monthly journal.
What was it called?
It was called the Woolsack.
The Woolsack.
The Woolsack.
And what does that come from?
That comes from a reference to the seat, a pillow-like arrangement that English judges would sit on a woolsack when they were on the bench. And they, out of a sense of mockery, I think they called the monthly journal the Woolsack.
But not only were you writing there, but you were also writing for the Law Review, as I understand it.
Yeah, I wrote 2 articles for Law Review. My career didn't take me that direction that I thought it was going to take. It's always a surprise where things go. I wrote an article on 16B.
Securities and Exchange, okay, Rule 16B.
The issue dealt with whether you became an insider trader, which then you have restrictions on your buying and selling, or selling and buying. And the issue is when you bought in, you were not an insider trader, but you became one. Were you an insider trader then when you tried to leave your investment? So that was an esoteric article that no one would read. And then I wrote an article on the Investment Advisors Act of 1935, which I have actually used the title of that Law Review article several times and actually referred a lawyer to it within the last month. The Latin phrase ubi us ibi remedium, where there's a right, there's a remedy. And we're still in law today addressing if the legislature gives you a right to something, do you have a remedy, a civil right to sue under that protection? Okay,
now tell me, you also achieved a position with the Law Review staff in your senior year?
I was editor-in-chief of the Woolsack, which is not the Law Review, but it's a monthly journal.
Were you on the Law Review board then? Or?
Yes, and I would have been an articles editor, mostly just doing footnoting. I did my clerkship with the AG's office the summer before third year of law school, and I worked in consumer protection. An attorney by the name of Julian Garrett, he's now a legislator, was my boss. We had 2 law clerks and 3 attorneys plus the director, which would have been Julian Garrett.
And Richard Turner would have been the Attorney General then?
Yes, Nick Turner was the AG. During that summer, I did a lot of research, a lot of consumer complaints, drawing up lawsuits, consumer protection suits, which was a new thing in the law then. I helped assisted the Attorney General writing a couple of Attorney General's opinions. I discovered on what a colorful character he was by sitting right with him one night, working till 10 o'clock, because he had a conference to go to, the National Attorney General's Conference. He had to get it done by that night so he could get the opinion out. And another attorney, Scott Peters from Council Bluffs, he and I fished him through an AG's opinion declaring a statute unconstitutional. And he wasn't going to enforce it. The law provided that he had to collect a $10 fee from anybody that extended credit, and which would be tens of thousands of people mailing in $10 because they were a creditor. And he declared that unconstitutional. It was so funny back then. An assistant AG that I had gone to high school with, he was a little older than me, but had recommended me to General Turner. And Scott Peters was from a pretty established firm in Council Bluffs. But during the writing of it, he was dictating it as we tried to help him through the pitfalls of constitutional law. He finally stopped, he said it in a profane way, but which I won't repeat here, but he doesn't any Republicans work for me, he declared. And we all just kind of shrugged our shoulders and went on with doing the work that we were hired to do.
Now, all that federal writing for federal law would have made you a good candidate for a lot of big law firms. What was the job opportunities like what year did you graduate?
1975.
Okay.
And there were no jobs in law anywhere to speak of. In California, I sent out probably 100 applications for jobs everywhere, a lot of it in the public sector, but I decided I had to come home. I was running out of money. So I came home to live with my parents. My dad was he eventually got promoted in the oil company that he worked for, and he had moved to Omaha, Nebraska. So I lived with them for a couple months. I had been hired by the Commodity Futures Trading Commission, and the guy called me that summer after I graduated and said, "You're still hired, but we have no money to pay you." The Congress had not appropriated funding for the Commodity Futures Trading Commission, which was going to be like the SEC, only in regards to corn and soybeans and pork bellies and future trading, gasoline perhaps. And so I wasn't going to work for nothing. And in that process, a lawyer up in Fort Dodge, Iowa, Tito Torino, called me and said, "Hey, I know of a couple lawyers down in southern Iowa that they're looking for a lawyer, especially if somebody can try a case." And you look at your false sense of competency, maybe. So I just drove over to Sheraton, Iowa, and interviewed with Dick Moore and Bill Shelton, and they hired me, I think, on the spot. So that's how I ended up in Sheraton, small town Iowa.
Had you taken the bar exam at that point?
Yeah, I was admitted to the bar.
So you could hit the ground running for them.
Yeah, back in those days, the Iowa bar exam was given in June, and the people taking the bar exam would know the results on the fourth day. It's a 3-day exam, and you'd know by midnight of the third day, and they'd swear in on the fourth.
The good old days, as some people think.
Yeah, it was a good old day. And then I was leaving to go take the Nebraska bar exam. I had studied for that. Admiralty was on their bar exam, surprisingly, for Nebraska. But Nebraska has a real easy petition-in provision, so I just got petition in because I had been admitted.
They had reciprocity.
But then I went back and studied for 2 months for the California bar, and then took the California bar. So it was funny taking the California bar. All my fellow students at the University of San Diego, you always go, "Well, you're already a lawyer. Why are you doing this?"
Yeah. Okay, so tell us a little bit. Sheraton is a Lucas County seat, town of about 5,000 when you got there.
Good, exactly.
And what kind of practice did Dick Moore and Bill Shelton have?
They had a general office practice as typical of small town lawyers, and they did tax during tax time and real estate deals, and then litigation from time to time. I came in as assistant county attorney, and that particular county attorney job, Bill Shelton was the county attorney, and he did it with many assistants. He'd just tell you, "You're the county attorney, I just don't want to read my name in the paper." And so less than 7 days after I started on a Thursday, I vaguely remember, and the next Monday or Tuesday I was trying a jury trial.
And what kind of jury trial was it?
Well, it was an OMVUI, as they called it.
Defending?
No, I was
prosecuting. Okay.
The Bill Shelton walked in and threw a file folder on my desk and said, "Well, you said you know how to try cases next Tuesday over in the courthouse." "Yes, sir." "What is it?" "It's OMVUI." And he walked away. And I came from California, where we call drunk driving cases a deuce because the statute entered in 2. And I go, "OMVUI, I wonder what that is." And I open it up and my word, that's the initials for operating a motor vehicle while under the influence. And so I went and tried it that next week for my first jury trial in Iowa in front of Judge Bound.
Thomas Bound from Corydon?
From Corydon. He was an Old Salt, former veteran. he'd be celebrating today if he was alive.
Yes.
But he taught me a lot, trying cases in front of him. And so that was my first jury trial.
You going to tell us how it came out or not?
Well, at the time there was a 1983 action, which is a civil rights provision coming out of the arrest. The man that was arrested for OMVUI, as they called it back then, had gotten hurt during the arrest, and he had sued for violation of his civil rights. The young lad that was trying the case was not told about the importance of the prosecution, so I tried it without knowing that. Bill Shelton came with me and helped me pick a jury, and which I thought was very helpful. Every state has their own customs and how they do things. So they swore the jury in, and he patted me on the arm and said, "Good luck, let me know how it comes out." And I was shocked. "Aren't you staying around?" "No, you said you know how to try cases." And he left me to it. So in that very first trial, I learned the rule in Iowa, which I actually brought up in a trial that I was trying about 3 months ago, where lawyers in Iowa, it's an unwritten rule, are not permitted to stand during cross-examination of a witness. And I stood up to cross-examine a witness, and the other attorney objected, and the judge said, well, everybody knows you should not do that. Please sit down. And I had never heard of such a rule in my life. But during that trial, I was, full of myself, as I knew everything, and I had been well educated, and some evidence was being offered in, and I objected to the judge. Objection, Your Honor. It's impliedly assertive conduct, therefore hearsay, no exceptions. He asked me to repeat it, which I did. And then he stopped and he looked at all 12 members of the jury, and he looks at him and goes, "Never heard of it." And then he overruled my objection. Talk about a quick education by a trial court judge. So that was my first trial. I had been working less than a week, my first jury trial. Okay. So I tried a lot those first few years.
Let's go back then to practice in Sheraton, Iowa. Tell us about the cases you tried. It sounded like you did a lot of them.
Yes, just all the garden variety of cases that a small-town lawyer gets. Real estate, brokerage fee issues. I remember trying a jury trial of that, and we were successful on that. I was successful in my first OWI.
Oh, were you?
So,
okay.
Which was a close call. But
I wasn't going to ask.
Yeah, you always want to win your first. But just a general county litigation. I did a lot of litigation, but I prepared taxes too. I wasn't that good at preparing taxes, but I had a client, one of my first clients, and they're the worst. He was what we'd call a good farmer, scientific farmer, knew the tax code inside and out. And it was about my third revision of his tax return. And he finally went back to see Dick Moore, who had hired me. And he says, "Do I have to have Mike do my tax returns?" And he goes, "Why?" "Well, I know more about tax than he does." Which I could have at that point in time, I could have taken a tax appeal to the United States Tax Court, because I had studied that in law school, and one of the few people that emphasized all that type of securities and tax in my law school education. But I had never worked a return until I started at a small town firm. So I was learning myself, and here was a pretty experienced farmer.
Who's teaching who here, huh?
Yes. He did teach me a lot about farm returns and what to do with a 4797 asset.
Well, that's interesting. All right, so now we come to 1983. And in 1983, Iowa is in the midst of a farm crisis. And you are appointed by Governor Branstad to the district court bench in southern Iowa. This would have been a new position? No, you replaced someone.
No, this was a new position. The legislature that spring had declared a new seat in 5B, southern Iowa, the southern, more than just the two tiers, but the southern part of the 5th District. They created a new judgeship because the farm crisis was starting to blow up. And it had a terrible effect on the farmers in southern Iowa, more so than the northern Iowa farmers. And as a result, we had a lot of court action, a lot of foreclosure work, a lot of issues concerning security interests in grain, and even in cattle. Plus, we were near the Missouri border, which led to problems on security interest in grain. So, because of all that extra fight,
moving the grain across the border, into Missouri, and livestock as well, I suppose.
Yes, and as a result, in fact, I remember trying a case in Newton, Iowa, where a farmer hauled grain about 100 miles away to sell his corn and beans, and the poor elevator had to pay for it twice because they didn't do a check on whether it was secured property or not, which it was. Now, as a result of that, and the tragedy was these farmers' lives. They were losing their entire livelihood because of interest rates and the drop of the price of corn. You have to remember that Jimmy Carter was president and had embargoed us ourselves from shipping grain to Russia, or to the Soviet Union then, to the Soviet Union. Price of corn dropped to about $1.50 a bushel. Interest rates shot up to over 20%. And that just hit the farm economy so bad, and these individual farmers, and they saw their lives just evaporate.
This was due to inflation and Paul Volcker trying to squeeze the inflation out of the economy, so the prime rate went very high.
Yep, all those factors worked to the farmer, especially the leveraged farmers, and they themselves dug their hole a little bit because just before that happened, there was a boom in agriculture, and you could buy farm ground and then resell it within a year or two and make money on it. And everybody thought that would never stop. Well, it turned out it did when all these factors started to bear.
Mm-hmm.
The price of farm ground was dropping, and then it just rolled over into the court system, all those things.
Is there any particular trials that you did as a district court judge that you'd like to tell us about? Did you make court TV, for example, or are there other cases that you thought were interesting?
I hate to say I was an early star of court TV, and in their annual convention for years, I was invited to come to New York to be part of their annual meeting. We televised a trial. Came out of Polk County. It was a lawyer accused of suborning perjury, and in court TV back then, that was a network, and they would broadcast live court proceedings throughout the United States. And then if you were a particularly interesting case, they would do the highlights at the nighttime show. So our case was tried in the 4th floor of the Polk County Courthouse, and it went on for a full week. A lawyer was charged with suborning perjury, and it was quite a colorful case. It involved a baby that had shown up at Iowa Methodist Children's Hospital for some problem, but the doctor noticed that there were bite marks on the baby. They called the police. The parents ran out of the hospital with the child and the lawyer, and then he was eventually charged with suborning perjury for testimony offered in regards to the child case. And so that was televised, and as a result, I talked to the Supreme Court people on televising trials, because eventually Iowa became a leader in the United States of how we try cases in the public on television for the sake of educating our citizenry and what goes on in a trial court. So that was one public notable case. I had a friend that he was a farmer with those big satellite dishes on their farm, and he called me one night about 11 o'clock saying, "What the heck? What are you talking about? I'm catching the feed from New York to LA, and you're the main part of the feed. What's going on?" And then I told him about that trial. So it was quite a deal for them to happen. Years later, When I was years later, I was 3rd Assistant Chief in the 5th Judicial District, and I was in town that day in Polk County. They came in and said, "You got to decide a big issue." What? Our building manager will not allow court TV into the building. Oh, why is that? Well, the last time they were here, I think it was your case, they left a lot of duct tape, stick them on the floor, and Tommy couldn't get it off, and he's not going to let him do it again. And I go, well, why does the 3rd Assistant Chief have to do this and not the Assistant Chief? Well, the only one ahead of you that's available is Judge Novak, and he doesn't want to screw with it. So I had to be the mediator there, and we extracted agreements. The local reporter for Court TV is a national reporter now, and I instructed him that we have jurisdiction over him, and the stickum from his duct tape, which they taped the cords down onto the floor so people don't trip. He promised me that he would personally see that all the stickum was taken off the floors in the Polk County Courthouse. Another case, though, because you were asking about the trial bench, is I was called one night by the chief. It was Chief Moore. He had become Chief Judge of the district.
And let's go back a minute. He preceded you on the bench by, he was an appointee in the 5th District in Southern Iowa, the judge before you.
Yes, he and I were, of course, in the law firm together. I learned so much from him. He taught everything to me about the court and trial work. Bill Shelton did too.
And so he became chief judge while you are on the district court bench.
Right. He was appointed probably 80, 81.
Okay.
I followed him in 83, and then years later he was appointed chief judge, which the Supreme Court does that. They appoint the chief judges, and he was chief judge. And then he calls me one night and said, "Mike, what are you doing tomorrow?" "I don't know what." "You know, you're coming to Des Moines. You're going to sit on the Iowa Trust case." The Iowa Trust case was a case where almost 80, I think it was almost 88, but that sounds like a piano key thing, but over 80
lots of them.
State government, city municipal entities, county governments, of course, road funds, all these kind of different government entities had invested all their money, all their spare money that they hadn't used up, that they were going to use eventually, in a thing called the Iowa Trust. And it promised anywhere up to 15, 16, 18% interest on their money. If it's too good to be true, it probably isn't. And they turned around one day and it was all gone. And the Iowa Trust case started.
Went on several years. It was still going when you got on the Court of Appeals, as I remember it.
Yes, the rollout, the case itself was done. I ended the Iowa Trust myself. But there were rollout impact on fighting over some of the proceeds thereafter between Bankers Trust and the Iowa Trust people. The first day of hearing, I was sitting in the chambers in Polk County, and I was resolving a forcible enter and detainer action where a tenant had not paid his $800 a month rent, and they're trying to kick him out of his apartment. And I finally interrupted the attorneys and said, "Well, counsel, it's 9 o'clock. It looks like we have this worked out, but they're telling me I have to be out in the courtroom for some kind of case." I had no idea what it was, other than it was called the Iowa Trust case.
And then Dick Moore told you better do this.
Yes, he told me to go.
Yeah.
And it's kind of funny. Some judges was wondering why a country judge was coming in to hear the big city case. And Dick Moore explained to one of the judges who was complaining about it that we needed somebody that he just never says no to me. And that was true. He said, "I need you up here," and okay, where am I supposed to be? And so I walked into that. The first day the courtroom was full of lawyers. Probably then there was probably 15, 20 lawyers there.
It's a meeting of the Polk County Bar.
Yes, a meeting of the Polk County Bar. That's appropriate.
And just for a minute, people, I think, who didn't know Dick Moore underestimated. He had a very lively mind, and he understood the complexities of finance.
Extremely so.
And so I think he probably knew that you did too, because of your background, as you just talked about, and doing the federal FCC Act stuff in law school. I think he knew how smart you were about these things.
Well, he had heard about. When I interviewed him, he asked me, "Why do you want to come to small town Iowa? Look at your credentials from what you did in law school. You wrote 2 articles on securities regulation, and you want to come to small town Iowa." And I finally had to tell him, well, here's what happened.
You and Dick Moore are good examples. Never underestimate small town lawyers.
Oh, it just amazes me every time, especially now that I'm not on the bench anymore, and I go. Being a judge in the small towns and all these county seat towns was a delightful job. It was great working with these lawyers. So many of them are so smart, so bright, and they understand something about everything. Not a lot about one issue, but they know a little about everything, which can get them in trouble. And that's what I love about small town, being a small town judge.
And let's get you back to the Iowa Trust case. These people eventually got their money back, as I remember it.
Yes, they and it played a role. Governor Branstad told me, and then friends of mine. The reason I appointed Mike to the Court of Appeals was how he handled the Iowa Trust case. And I don't want to brag because I think half the judges I know would have done exactly what I did. But the Iowa Trust case had about over 80 government entities losing about $225 million. You have to put yourself back then on the value of that. It'd be over $500,000 today. And they had nowhere to go. And in that case, I was confronted with it that morning. All those lawyers, quiet lawyers working tough laws, but also struggling with just they don't know where this is going. And then lawyers trying to stop us from doing anything, representing the trust itself. We can do this. And I made a pretty split-second decision to take over the Iowa Trust, to declare a receivership. I appointed David Lyons.
The insurance commissioner.
He was the insurance commissioner as my receiver of the Iowa Trust, and sent him on his duties to go find our money. And he did a wonderful job at that. And they got all the principal returned. They had to file lawsuits in Colorado, out in California, multiple jurisdictions.
He followed the money.
He followed the money. He did a great job. He had some really good assistant attorney generals and the attorney general themselves working on this. The attorney general at the time was Miller. And by the end of about a 2-year period, we had all our principal back, not much interest. But this was money that was stolen. And the key reason, and I say half the judges would have done exactly what I did, was I didn't even leave the bench to make my ruling. I think if we'd been 2 weeks late, we would have lost all the money, because the identification of the money in the stream of commerce would have been lost.
Mm-hmm.
And
it's pretty fungible.
Yep, they could put their finger on, that is our money, that is our money, that's our money. And because of that, they clawed it all back into Iowa, got all that money back, not much interest, or not any interest, I don't think. But that was the key to the Iowa Trust case. Then we disbanded everything in about 2 years, and then they were fighting over some extra proceeds that were coming in between Bankers Life and some of the individual counties involved.
That was a very important case in Iowa. I personally remember, because our firm was tangentially involved for Polk County, but it was remarkable to me that the money was recovered. I mean, I thought, I was there at that first hearing and watched you do that, I thought the money was lost, frankly. I just thought, this is gone. But I thought you did a great job, and it was terrific.
Let me tell you about one case, though.
Oh, sure.
Everybody in Sheraton thought I moved to Newton, Iowa, because we had a homicide of a police officer in Newton that I had 2 trials over, and it was a nationally publicized issue because it was a police officer getting killed.
Did we make court TV again?
They did report it, but they didn't broadcast the trials. We tried 2 defendants. They were holding up a Hy-Vee food store in Newton, Iowa. The police officer showed up tried to stop them. They pulled out their guns and shot and killed him. The police officer had been teaching Boy Scouts how to shoot skeet with his patrol shotgun, and had failed to reload with what he should have had in a double-aught buck. He had bird shot in his gun, so he was ineffective. One of the defendants, who was eventually arrested up in Minnesota, he had tooth or so knocked out and peppered with bird shot, but it didn't stop him, and he escaped and was gone for about 6 months, and they finally tracked him down. One of the defendants was an escapee from Fort Madison, a planned escape with a getaway car and everything. We tried him, his name was Gladson, we tried him in Winterset, Iowa. And Lamar, that trial was here in Polk County. We had to change away from Newton for the obvious reasons. And that was just an emotional, hard-fought case. In fact, in Winterset, I asked for, because don't forget, this defendant had escaped from custody when he was in Iowa City to get treatment on a hand injury. The deputy turns around and he was gone, and he had a getaway car. It was all planned. And then 6 months later, he's robbing the Hy-Vee food store. Well, we had a lot of security necessity with that particular defendant. It was the first time, they tell me it was the first time, that I requested security on everybody coming into the courtroom. So they set up a metal detector, which we consider routine today.
Yes.
But a metal detector in the courthouse to just get in the courtroom, not the whole courthouse. And they did what we traditionally know of as the metal detectors, and the bag of things that go outside the metal detector. They didn't have a scanner like we do now for bags and stuff. But in that trial, they were very much aware of security issues. And at one point in time, I asked the sheriff, are you scanning their individual personal property like we expect today? But he said, no, should we be doing that? Well, you should at least look at what they're doing outside the x-ray. And when they, especially, well, just, you should do that. So the next day, because it lasted over a week, this trial, the next day they did start looking at personal property that was put in the tray that they didn't scan, but it would go outside the metal detector. And when the brother of the police officer that attended every day of the trial, the brother of the police officer, he was always carrying a big Bible with him. And the deputy took the Bible and opened it up. In the center was hauled out.
A revolver.
There was not a gun in it, but he was conditioning everybody that this is my Bible. And but a hole was cut in the middle of the Bible to put a gun. And I didn't suspend his right to be at trial, but it sure was fortunate that we had metal detectors, even though we didn't catch the gun that he was eventually going to sneak in. But it put everybody unawares.
Yeah, you were cautious.
Yeah, and then it was just because of the defendant itself. Now today we consider that routine.
And they both were convicted and got life sentences? Yes,
they did. They've come back. Mr. Lamar has come back more than Gladson. Gladson was the escapee that Mr. Lamar came back for post-conviction relief. I think 5 years ago or so.
That didn't work, I bet.
No, they'll spend the rest of their lives in prison.
Okay. All right, well then let's now move on to the Court of Appeals.
Okay.
And I believe you were appointed by Governor Branstad in 1996?
Correct.
And by our calculation, did more than 600 opinions on the Court of Appeals. At the time, how many members of the Court of Appeals were there?
We started out with 6. They had already gone from 5 to 6.
And then eventually to 9?
And then 9, my last year and a half or so was with 9.
Okay, so with 6 people, you're writing, I mean, that's a lot of opinions.
Yeah, I think we averaged about 120 each
a year.
Each year for each of us.
I think, okay.
Yeah.
And
it was funny, when I interviewed for the Supreme Court, Governor Vilsack came in and he had about a foot and a half of paper. And he's an attorney. He goes, well, we had a good weekend and a bad weekend. Well, what's the good weekend? Well, my wife Christy was in for a minor medical thing, so she had to stay overnight in the hospital. And that gave me an opportunity to look at your application for the Supreme Court. And I said, what's the bad part of it? He says, I had to read over 600 cases that you wrote for the Court of Appeals. And I made some quip that, well, that sounds like fun. And he was so well studied. He had about 6 cases he wanted to talk to me about, why I decided it this way, what was my reasoning, did you see this problem, what did you think about this?
Wow.
He was a student of whoever he was going to appoint to that court.
Do you recall who your competition was for that?
Boy, that's a tough. Oh, Art Gamble, the chief judge.
Art Gamble.
Art Gamble had become chief of the district by then, and Art Gamble was nominated against me, and then Tim Finn, a judge from over in Marshalltown.
All three of you would have been good. That's the advantage of the Iowa system. You get the choice is very hard because all three are very good candidates.
Yeah, and they were all judicial candidates. There was a swing, I think, the prior times that had a lot of non-judges, lawyers appointed. Marcia Turnus was a lawyer that had not been a judge. Even though she wanted to be one, she was on the nominating commission and couldn't apply for the trial court because her commission was still active. Of course, the Iowa Court of Appeals, you have a lot of routine cases.
Yeah.
I was talking to our cameraman off camera a little bit, how he remarked how he liked my writing style on things that I would do to start a case to get attention.
Yeah.
And one of those cases that made some national news because it was just so funny was a case called the Beanie Baby case. And it's not a big case. It was and the only reason it made such national news is I quoted the homeowner himself who burnt down his house. He was so mad at his wife for filling their house up with Beanie Babies. She got caught into this trap thinking if we buy these Beanie Babies, they'll be worth millions someday. And he had hundreds and hundreds of Beanie Babies throughout his house, and he got sick and tired of them. So he piled them all up in one pile, lit them on fire, and burnt down his house.
Not intentionally. He only wanted to burn the Beanie Babies?
Yes, and he got away from him. And under most law, an insured cannot collect when they intentionally burn down their house. And they weren't going to pay the wife, who said, I had nothing to do with burning down the house. I should at least get half of my money. And we eventually did rule that way. I'm not sure how the case went in trial because we never heard of it again. But
so how did your opinion start?
My opinion started with, it wasn't a colorful quote, but it started with a quote of what he said, muttering about the God-blessed Beanie Babies as he was piling them up and setting them on fire, which was just hilarious to read on how he handled the Beanie Babies out of frustration with his wife.
Okay. As the result of this meeting with Governor Vilsack and his looking at 600 opinions and talking to you about several, he made the decision to appoint you to the Iowa Supreme Court.
He did.
And that happened in 2001?
Correct.
Okay. And you served there until 2010. And by that time, had the court size been reduced to 7?
It had already been reduced to 7 before I got on the Supreme Court.
And who did you replace?
I replaced Justice Snell.
Bruce Snell from Ida Grove.
Correct. His father had been a Supreme Court justice. He always referred to him as the real Justice Snell. Of course, that wasn't true. He was a fine justice. Still is a fine man.
I think this would be a good time. We'll talk about your efforts on the Iowa Supreme Court, but I'd like to talk a little bit about judicial philosophy, I guess what I'd call your judicial soul, your psyche, about what's it like to be overruled, what's it like to be in the minority in a case. So I know Southern Iowa in the 5th District had a reputation for ruling from the bench, loneliness as a judge, all of these kind of things. What was it like for you to be a judge and your judicial philosophy? Would you like to tell us about that?
Well, it's
It's a big topic.
It is a big bite. It's kind of like I was addressing about 60 people up in Mason City one time, and one of the questions from the audience was, is there justice in the Iowa court system?
Yeah, well, I hope I wasn't that broad, but yeah, that's sort of what I'm doing to you.
What happened when I was a district court judge, it reflected what I did at the appellate level also. I was taught by some wonderful mentors, Dick Moore, Bound, Judge Bound, Thomas Bound. A.V. Haas was an eloquent writer. He was a wonderful judge, quiet man. He put 3 things into one sentence that we would take 3 sentences to write about. He was a gifted writer. He himself helped me out one time. I was in court where I was talking about they had failed the other side. I was prosecuting a case, and they didn't call one of the witnesses, and it didn't dawn on me I couldn't say this, but I started to say, well, they failed to call such and such as a witness, that if they were in favor of them, they would have testified. And Judge Haas, in the back of my head, because my back was to the court, I was to the jury, he goes, that's far enough. And it, just instantly I knew what he meant. Oh my Lord, I'm switching the burden of proof to the defendant, which you cannot do. But from those judges, I learned how to be a judge.
You also told me another anecdote about Judge Haas, about a motion you made once.
Judge Haas also looking out for me. It could have been in that trial, because I was so eager. You look back on that, the energy you have as a young attorney. I was making a motion to allow some evidence in, and Judge Haas looked at me and he says, just very quietly, you really want me to rule that way? And it finally, oh, he's sending me a clue. No, Your Honor, we withdraw the motion. Good call. And we went on to something else. And I think trial judges today are not quite as involved sometimes. He was more like a referee, but when he saw you getting off the tracks, he'd try to help you out, and not to the detriment of, he did it all in front of everybody, but he would always give a helping hand to a younger lawyer, an inexperienced lawyer. I
too found him a delightful man to work with, and there's the great story about him in Ottumwa, a personal injury trial between Kenny Keith and W.T. Barnes. And they both ask, they've been at it for a week, and one of them makes an objection, the other one moves for mistrial, which had been going on for a while, but finally the other one moved for mistrial too, and
A.V. Haas finally says, well, since there seems to be some unanimity here, I'm going to grant the motion for a mistrial, and it just shocked the lawyers. They hadn't dawned on them that a judge would eventually give you a mistrial, because none of them really wanted a mistrial.
No, they didn't want to start over. And I'm told the next trial went very, very quickly and smoothly.
Yes. Well, I had that same kind of experience, but I couldn't. I had an assistant attorney general. I was a county attorney at the time, and it took us forever to get a regional area prosecutor, because I had a conflict of interest. I was going to testify at the trial. It was on a perjury case, and it took us 9 months to get him down to try the case, and we had a big dispute. We were in the right, the judge was wrong, but in chambers he moves for mistrial in front of this judge who was angry already, and I physically grabbed him to try to shut him up. We don't care, just let the jury decide. And the judge had actually rapped on the desk with his hand, and he says, motion for mistrial is hereby sustained. And I wasn't going to be able to get that assistant AG back for another 6 months probably. So you
don't ask for things you don't want.
Yeah, and you learn that real well. But to go back to judicial philosophy.
Yes, please.
What I learned from them, and one of the quirky things of southern Iowa, 5th District work, is ruling from the bench. And it seems so funny, because I've taught it to judges, because in the state of Iowa now, the judges tend to take everything under advisement, and they're going to get you an opinion within 2 weeks if you're lucky, sometimes within 2 months. Now in Iowa we have a 60-day rule, it's called Rule 210, that requires you to decide your cases within 60 days or tell us why you haven't done it. You don't have to file them, but just tell us why, the ones that are 60 days old and why you haven't decided it that way. And if you talk to the rural judges back in the day, we had hardly any of those, hardly ever would we take a case, because a lot of times we'd rule on the rule from the bench. And our philosophy was, you know the case as well as you're ever going to know it, and you're pretty good in the law. Make your ruling now. Don't take it out to your car. Don't throw the file in the back seat, hoping to get to it sometime. And because of the traveling nature of the judiciary in the rural sector, that job just forces you to do it that way, because you don't have a credenza to stack your files on. And as a result, I think I've gotten so much appreciation from lawyers that just appreciate to get the decision from you now rather than a month from now, and wait and wait and wait. The goal of all the judges that I know is to be fair and impartial, to rule according to the evidence and the law as they perceive it to be. And sure, sometimes judges, just like any other lawyer, has to study the law, and that's why they take it under advisement. Sometimes they do have to study the facts themselves. What are the facts? They've thrown it all at me, but I still have to ferret it out. One time I had to file one of those reports. In my last 10 years as a trial judge, I didn't file any 210 reports. It was called the Rule 200 back then. But I filed one of my reports that, and they asked, what is the reason that you have not filed a case in 60 days?
Don't have any.
And, well, I had one.
Had one.
And most judges write caseload or workload, things like that. And my answer was just thinking. So I got a call from a court administrator in Des Moines and said, yeah, I just wanted to call and tell you that's the most unique answer we've ever had. And he says it's the most honest because, yeah, I was just thinking hard about the case over and over.
Some judges have a sense of loneliness being on the bench. You've always been a very gregarious kind of person. Did you feel that?
I never did. I enjoyed the work with attorneys in the trial court, and then at the Court of Appeals it was different though, because you do sit alone. I happened to locate my Court of Appeals office in Des Moines in the Capitol. Now some of those Court of Appeals judges don't move to Des Moines. They sit in the county seat courthouse where they do their work, and they'll see the lawyers much more commonly then. I never felt isolated or alone, except in the work. You can't talk to lawyers about, oh, I'm struggling with this case or anything like that. So I never felt that loneliness, but you do sometimes when you just have that bear of a case that you can't talk to anybody about. I had a reminiscence of that. I was hired as an arbitrator a couple of years ago on a terrible case involving a major university on some very secret stuff. And the case was submitted to me for arbitration. It's very private. It's not a public trial. Both sides agreed to submit it privately to me.
Mm-hmm. So you have no one to talk to?
No one to talk to, in arbitration especially. And the lawyers came in and argued it. And they went back to their offices and then submitted briefs. And I go, oh, this is what the loneliness is. Mm-hmm. Now, as a trial court judge in Court of Appeals, I never felt that very much, because we're still in our community of people that you can work with and you work with every day. But
that's one of the advantages of being, I found, in a large firm, is that if you can walk into one of your colleagues' office and in a very neutral way explain your problem or your case or whatever you've got, and then ask for another opinion about it. What do you think? And I mean, there are those who expect it, who will do that to me and expect a specific answer, which is just awful. That doesn't work. But were you able to do that in the I suppose you are, aren't you, in a district court or in the Court of Appeals and even in the
yes, you can.
In the Iowa Supreme Court.
There's a particular judge that you and I both know very well, that he'll come in and close the door. He was a trial court judge until he retired, but he'd come in and say, Mike, I want to talk to you about a case. And he'd walk back and forth, walking back and forth in front of my desk.
On the quarter deck, huh?
Yeah, and he'd be explaining. Every now and then he'd just ask a question. And he'd do that for 15, 20 minutes. And then he goes, oh, great, thank you. You've helped me a lot. And you go, I haven't told him a thing of what I think about the case.
You did.
But just listening to him, was therapeutic enough, and not in the mental health therapeutic, but it was therapeutic for his decision-making on the case.
Listening is one of the most important qualities, it seems to me, of a judge. Just being able to sit and listen. And
I don't know how many times I tell that. When I taught new judge orientation, I originated the program 20 years ago, almost 30 years ago now, on new judge orientation, and that was always part of the program to new judges. In fact, they had the new judge orientation program for our new judges in Iowa last week here in Des Moines. And that's one of the things that I myself have that problem. All lawyers do, but learn to listen. It's so hard not to interfere. And sometimes I always interrupt and ask questions. But listening is probably one of the best assets for a lawyer to have, but also for a judge to have, is to listen.
Let me move then to your time on the Iowa Supreme Court. And I know there are some cases that you'd like to talk about. The one that struck me in looking at this is the expansion of rights and interpretation of the Iowa Constitution by the Iowa Supreme Court. And one of those cases that I think sort of started it, but you tell us you know more about than I, is Fitzgerald versus Racy? Was it the other way around? Racy versus Fitzgerald? I can't remember. But anyway,
I think it was Racy versus Fitzgerald.
Racy versus Fitzgerald, thank you. And it dealt with the taxation of casinos as opposed to riverboats, as I remember it.
Right.
And tell us a little bit about that case and the beginning of a real expansion in interpretation of the Iowa Constitution.
The R in Racy, it's R-A-C-I, and the R I think stands for racing. But it came out of Prairie Meadows here in Des Moines. The case itself was the differential tax rate between racing casinos, horse racing, dog racing, versus riverboats. And the casinos with the horse track were taxed at 36% of gross. It's a graduated scale, but the high end was 36, versus the slot machines at the riverboats were taxed at 20% or 20% I think it was. And we determined that under state and federal law, that's a violation of equal protection.
The constitutions of both.
The Constitution. It's two and equal. And we reversed the trial court and found the differential rate unconstitutional. That went up to the U.S. Supreme Court. The U.S. Supreme Court, they almost should have sent us a memo saying, I'm sorry you didn't get the memo. Under federal law, we don't apply equal protection to tax law, because tax law, there's no sense under the conduct of equal protection federally to try to make sense.
If there was a rational basis, that's all it takes.
So they reversed this, sent it back down. They re-argued it under only, well, they sent it back down for further proceedings. When it came back to us on what we call Racy 2, Justice Turnus, I wrote Racy 1. Justice Turnus wrote Racy 2, where the reasoning was under the Iowa Constitution, it's a violation of equal protection to have such a differential between taxes on the same activity. And the factual part of the case is that the Prairie Meadows versus the riverboats, 90+% of their revenue is from slot machines, period. Not from horses running around a track, not from poker being dealt at a game or roulette or anything like that. Slot machines. They're the same thing. There's no rational reason why they're taxed at such a huge difference. And the state could not put forward a good enough reason why there's differential in the rate, so we threw it on under state constitution of our interpretation of equal protection. Now, as a result of that seed being planted, I think our Varnum case and cases along that line, there were a couple cases before Varnum along the same line, and then Varnum itself, and then there's post-Varnum cases concerning the birth certificates and things like that, that all come out of that decision making, that the state constitution is a real document. It has its own legs, it stands on its own. and that we should apply that in our interpretation of what is due process, what is equal protection to our citizens. And our equal protection, constitutional provision for equal protection is a little more vigorous than the federal one on differentiating treatment of people of like circumstance. And we determined that in applying the Iowa Constitution to marriage equality, that there was no legitimate state interest justifying a different treatment of gay couples versus heterosexual couples. And we threw out the state ban declaring that marriage could only be between a man and a woman.
Well, we got into Varnum versus Breen. Before we discuss that in any detail here, is there any other cases you'd like to talk about in your tenure as the Iowa Supreme Court from until 2010?
Well, that's like a huge question.
Yeah, it is.
If
I know.
I could sit down and have a list of those 106. One significant case to me, but it's kind of an egghead type of case, was the Microsoft case. Under the antitrust laws. And this is despite a state statute that says, it doesn't say if possible, but they said that our antitrust law should be, it should be endeavored to interpret it similar to federal law.
We have a mini antitrust law, yes.
And in the Microsoft case, people that had bought computers with Windows, which is a Microsoft product, they wanted to sue for antitrust. And of course, Microsoft says, who are you? We didn't sell you anything.
Yeah.
We sold this to Best Buy to put in their computers. Or we sold it to Hewlett-Packard or to Dell. We didn't sell you a thing. Well, under the shoe case, international shoe case, indirect purchasers were not permitted to sue the antitrust entity. And we reinterpreted that to say that doesn't make any economic sense in today's case. The international shoe case was drafted back in the 30s.
Yeah.
And it didn't make any sense modern-wise, and we determined that we were going to break from federal interpretation and that indirect purchasers of products such as Windows, that they bought their computer from Dell, could sue for antitrust violations. And then as a result of that, then they started the Microsoft case, which was tried here in Polk County. It was settled after about 6 weeks.
In a trial, yes, that's something like that, yeah.
Ended up with a class action settlement to where most households got about $200 for buying Microsoft products.
Okay.
And I thought that was a big case. It was a bigger case nationally than it was here in Iowa. I know a lot of jurisdictions took note of that, and they followed suit of Iowa on allowing indirect purchasers to pursue actions for antitrust. And that just boils down to, again, trying to seek justice for the citizens that present their problem to the court.
Okay. Well, let's then talk about Varnum versus Breen, a case that held that the same-sex marriage prohibition in a state statute was unconstitutional under Iowa's constitutional equal protection provision. It was not a popular decision at the time among some people, and raised in 2010 the specter of not being retained. You and Justice Baker and Justice Turnus went on to be justified by what the U.S. Supreme Court did with the same issue nationally. You want to talk about that? That was something tried here in Polk County by a district court judge. I think it went up on a summary judgment because the facts were not in dispute.
Correct.
And the Supreme Court unanimously ruled. Tell us about the argument and what you'd like to tell us about the decision-making process, and then after that the hubbub that occurred.
Well, let me say this. Our court was composed of 7 justices that had little or no prior political involvement in politics itself. Some members of our court were a little more active through, say, the trial lawyers and things like that, but as that case worked its way through the district court, none of us paid much attention to it, and they really didn't think it was ever going to get to us. But then Judge Hansen made a decision based on due process and equal protection. He found a law that banned marriage equality, that said a marriage is only a marriage between a man and a woman. And he did it on the basis of due process and equal protection. That just was revolutionary, the initial ruling to that case. And of course, we had the stories of one or two couples getting married under the court ruling before the court stayed it until it could be reviewed on appeal. So then it worked itself way through the appeal, took a year and a half to process all the cases. We had amicus curiae brief, friends of the court briefs filed from about every organization you could think of, and many public entity groups, the Family Leader and things like that, even the Knights of Columbus. And I was a low-level knight back in the day. It just surprised me that they even waited on. They basically represented the Catholic Church, the Knights of Columbus did. So if you actually printed out all the amicus briefs, you'd have well over 2 feet of paper if they printed the briefs. Now, by then we were doing electronic filing, or electronic filing of briefs. We hadn't quite, we had gone to EDMS, but not at that level, I don't think, at the appellate level yet. So there was quite a lead up to that decision. When the case was argued to us, we live bit streamed that to the world, and citizens in Iowa could watch the arguments that were made. Years later, I was given a speech out at a big Methodist church out in West Des Moines or Walnut Creek area, and I said it was well argued on both sides, the case. And a gentleman came up and said, "I got a bone to pick with you." And I go, "Okay," because when you make a speech like that, then you get a crowd that gathers around the podium to talk to you about, they want to tell you their private story, especially in regards to gay marriage. Okay, what about? It was not well argued. I said, "Okay, great." And he was a proponent of gay marriage. In fact, he was an advocate for domestic abuse. His daughter had been severely injured by a spouse, and he was an advocate in that area, and he had the traditional views that that person would hold. But I said, no, I think it was well argued because the Polk County Attorney's Office argued the best they could with what they had.
Yeah.
And that case, the Varnum case, was decided on the basis that there was no legitimate state interest to treat couples that are similarly situated, and they are, and Justice Cady was the primary writer on that decision. There is no state reason why they should be treated differently. And it's a violation of our constitutional law that says they have to be treated equally. We did not explore due process. We didn't reject it as such, but the equal protection was a better basis to do that. It was argued live bit stream, hour I think on each side possibly. It was a longer argument.
And Justice Baker told us that you went over the opinion sentence by sentence in conference.
Yes, it's so funny talking to the justices later when we were trying to tell how it happened. Some thought, "Oh, you don't want to tell them that." No, we treated it as a different case. And that's why you don't want to tell them we just handled it as any routine case. Well, we didn't. We understood the importance of it. But 3 different times we projected it up on a wall like this in this room here, the opinion itself, and we went line by line through the whole opinion about 3 different times. You can't say that because we have one case that says this, just like you do when you'd edit any type of opinion. And we would trace it through, and we'd get done. Justice Cady would go back, do some editing, do this and that, and we'd reconvene again like a week later. And we did that 3 different times, and finally, okay, are we done? Yep, I think we're done. Everybody had their input. Each of us could probably point to some phrase or something that we had part of. Justice Cady was the primary writer. He wrote it in exquisite style. He's a great writer. Did a beautiful job. And I will tell this story about him. It was all done. Okay, what should we do? Well, let's put it out. And then somebody said, well, should we wait till the legislature's out of session? And I think it was Justice Turnus, and she'll probably deny this, but she says, we're not going to be political here. If we're done with a decision, we should just put it out. Let the chips fall where they may. Because if we would have delayed, it would have been less of a big reaction. I mean, the next day they're proposing constitutional amendments to throw out our decision, which is, they're empowered to do that, of course. But so we made the decision to go ahead with the filing as soon as convenient. But I was walking back to my office that day, and my office was right next to Justice Cady. He was not chief then. And he was just sitting there. You could just tell he was down. We were all tired. It was hard work. But I said, what's wrong with you? And he goes, oh, they sucked the life out of that decision. The group did. And I go, no, you're wrong. If you read it, it's a beautifully written decision, even though he lost some of his phraseology, some of his content, when you have a committee like that writing a decision. But he felt kind of down, and I tried to reassure him. Well, I called him about 2 weeks later because I had gone into my dentist's office. And the reception, who I've known for years, she goes, oh, Justice Streit, I read the decision. Oh, what'd you think of it? Oh, it was so good. I read it twice. And I said, well, I hope the citizens of Iowa
We'll read it twice.
will read it at least once, if not twice. And that's what we struggled with later then when the election came up, was the uninformed opinion. I gave an assessment to our court after our election, or our non-election, that we have to do a better job at communicating what we're doing in the court, to communicate with them, not necessarily get into a political battle, but just to explain our decisions. I've made speeches in almost a dozen different jurisdictions. And one of the things I point out to, if I'm talking to the courts, and I'm not always talking to courts, sometimes I'm talking to lawyers, is that we have to do a better job of explaining what we do. And I don't think we always retreat to the phrase, the decision speaks for itself. And we think that's adequate. Well, it'd be nice if it spoke to people if they would read it, but they can't, and they don't.
Yeah.
So I think our court system has to struggle with how we communicate better in the social media environment that we live in. We're not going to all. I'm not a member of Facebook or any of those kind of social media because our judicial training, even though I'm not a judge any longer, just the smart judges don't get involved in any of that. But the decision itself was well reasoned and stood on its own and was recognized then by the Supreme Court several years later. Now, they did both due process and equal protection, but it was very telling on how we did it. I spoke at the Harvard Club in Boston. I had speeches. I did speak twice at Suffolk University in Boston, but I was talking to a Harvard law professor that was at a dinner. He was actually married to a woman from Iowa. He goes, yeah, I get back to Sheraton, Iowa every 2 or 3 years for Christmas, and well, he'd been married to somebody that was a daughter of some school teachers in Sheraton, which I thought was interesting. But he complimented me on how well thought out the decision was, and how meticulously it followed constitutional law. And as I've said before in some public speeches, that the decision wrote itself. To go the other way would have taken much more work. When I was a Supreme Court Justice and Court of Appeals to a certain extent, every law clerk I had heard this from me at one time or not, is if we have to work this hard to get to this decision, we might be doing something wrong. Mm-hmm. And they would take that to heart because we'd worked so hard to do this and this, and let's stop then. Maybe we're deciding it the wrong way if we have to work that hard. Mm-hmm. The Varnum case, although we worked very hard on it, it was not a hard lift. It was well within the parameters of constitutional law. And I just don't think we could have decided any other way.
The logic flowed.
Yeah.
Yeah.
And so anyway, it had its impact here in Iowa.
We know it created an uproar at the time, and in the 2010 election. 3 of you, of the justices, were up for retention. There was a campaign by some people in Iowa to have people vote not to retain. There was a decision made by the 3 and maybe others on the Supreme Court that not to get involved in politics and not to get out and resist this in a political fashion. Tell us about why you decided to do that.
Well, we met, us 3 met, not the whole court. But we told them what we were thinking and why we were going to do this. Should we form committees? Should we raise money? Should we get involved in the political campaign? We thought that what Iowa courts have been and what they've been since we reorganized it back in the 60s is that we should not do this. It's not that we could not do this. Some people say, well, they couldn't legally do it. Well, no, we could have done that. Raised money, formed committees. There's a way to hide from the judges or justices who's donating to the committee. We could have got into all that political arena, but we made a deliberate decision not to do that. Justice Baker and Turnus and myself did public speaking. I think we won the Rotary vote, and maybe even Kiwanis, because we were all out on the road a couple times a week to give speeches. But that doesn't communicate to the broad public like commercials do. And they launch commercials. Witowski and Mark Hansen wrote a book, and in there they identified almost $1 million of outside money that came in on the campaign against us. And they far underestimate the money that came in dark money. So, for instance, Newt Gingrich contributed $350,000 to the initial startup of the resistance to the judges being retained in there, of the 3 justices being retained. We didn't find out about that until they were bragging on it after the election the next year. A year later, we found out that Newt Gingrich, in trying to become a president and sowing the seeds in Iowa, the caucus state, the first in the nation, let me start with the evangelicals. So he paid for a big conference to come to Des Moines. I think it was in Des Moines. I don't know where the location was, of all the evangelical ministers, and promised to support them on whatever cause they wanted to do, and they picked the gay marriage one out of the blue. And he contributed $350,000 to that effort to hire 2 professionals and a half a dozen staff people to start the campaign against the Iowa judges. Now, a local politician picked up on that mantle and carried it to their victory eventually. So
it's a tough time.
That was a tough time. We were counting on the Iowa bar to come in and start a campaign against them. We told them what was going on. We'll take care of it. They, and I don't fault them at all, they underestimated the effectiveness of the anti-campaign. Yeah. And by the time they realized what was happening, it was too late.
Yeah. The
train was already pulling out of the station.
I think President Moore at the time tried. I think you're right, underestimated. I gave some money. I think a lot of people did, but it wasn't in the range of Newt Gingrich.
Yeah, that was just the beginning. The real estimate is probably more closer to 3 million came into Iowa, of which we only know about 1 million. Because when they hire somebody in Iowa, if it's not for the election, because they hired somebody to consult with them on marriage issues in other states, well, then they don't have to tell our campaign ethics people about it, because they didn't hire them for this campaign. And that's how they get the dark money coming into Iowa. And you don't want to be bitter. And so anyway, that came and went. The election was held. It was too late. I remember getting a call the night of the election from my mother saying, well, you won. Do you feel good? And I go, Mom, we won in Polk County. And the rest of the state, it was like 56 versus 46, something like
44, that. 44, yeah, probably. Well, let's talk a little bit about then what happened afterwards. I think in 2012, I believe, you received a phone call from Carolyn Kennedy.
Yeah, I had started with a private law firm doing mediation work and arbitration. I get a call, and it was Carolyn Kennedy. And I said, well, good to talk with you. And I didn't even, it didn't even dawn on me it's the Carolyn Kennedy. And I thought any other call, but then I realized who it was, and she said, Michael, if it was okay, I'd seek your permission for me to put your name up to receive the Profiles in Courage Award. And I said, well, that's why? And she says, well, for what you've done because of your election and so forth. And in later conversations with her, I tried to pin her down exactly how it occurred, but she would not share with us how the nomination process began, how she got our attention, how we got her attention. And but I talked to her for quite a bit. I told her about how I'd known her uncles, Ted Kennedy and Robert Kennedy. Robert Kennedy, when I was 18, I was campaigning door to door with him in South Dakota, for him in South Dakota and Omaha. And I'd met him probably 4 different times, talked to him one-on-one a couple times. Ted Kennedy, not quite as intimate. I did spend a half hour with him alone once, where I talked to him, and that was when he was running for president. I was already an attorney then, and I was sitting outside at the venue where he was going to go in. I had no money it took $200 to get into the venue, and so I was just sitting out the lobby. One of my guys was going to try to sneak me in, but he couldn't get me in. And so Ted Kennedy sat down with me, and he goes, what are you doing out here? And I said, well, I can't get into this event. It's too expensive. And so I talked with him a while, told him how I'd known his brother Robert and stuff and things like that. But anyway, I shared those stories with Carolyn, and as soon as I hung up, I called Justice Turnus and says, do you think this is true or what's going on? And she goes, well, I think it is. And I go, yeah, my God, I talked to her for over a half hour. And Justice Turnus, she's a wonderful person, she goes, oh my gosh, what do you mean? I talked to her for 3 minutes. And I go, well, I had to tell her some stories. and she seemed to want to hear them.
Well, those of us who know you understand that.
That's right. So we went out to the Profiles in Courage Award.
That was terrific. May of 2012, you go to the John F. Kennedy Library in Boston with Chief Justice Turnus and Justice David Baker, and Ken Feinberg, I think, is the chair of the committee, and a nice ceremony on a Monday morning, as I remember it. You were given this a beautiful lantern.
Yes.
I think created by Carolyn Kennedy's husband. He was the designer of it, and it's a nice award, and it was a delightful ceremony.
It's a beautiful award.
And not necessarily that award, which I think is a great remembrance for what our justices did. But also, since then, you've been asked to speak on numerous occasions about judicial independence, and you've had a career in arbitration and mediation, which is still going on now. And as I said, don't want to talk about the private things you've done, but I want to go back to the Woolsack. Because there was an anecdote you told me about your son Ashton, who is attending your alma mater at the University of San Diego.
Yes.
And how life has changed when you, speaking of changing, in this case, diapers, and how life has changed for the court. And when you were on the Court of Appeals, and tell us what happened when Judge Habhab came in.
Oh, you're so good. I'd forgotten all about that story. Well, as I said, Ashton had been around the courts ever since he was born, and I had him one day, and he was only about 1 year old, and his diaper needed changing, and I put him on a footstool of a leather chair footstool ottoman to change his diaper.
A Woolsack.
A Woolsack. It really was exactly what they're talking about. In this 100-year-old ottoman that had been in that Capitol building probably since it had been built. And we inherited our chambers from the Department of Agriculture. And it was this red leather furniture that looked 100 years old. And anyway, I had him on there, and I was changing his diaper, and Judge Habhab came in and just watched me as I was changing my son's diaper, and he goes, "Oh, that's such a beautiful sight." to see a father taking care of his son this way, and he got a little teary-eyed, and you could just see the generational change between when he was a young man with children and I was a younger man. I was a little non-traditional on Ashton being such a newborn that I was in my late 40s when I got married. And he goes, well, frankly, when we had 3 kids, I think he had 3 or 2, he goes, I changed probably 3 diapers in my life. But he got a little teary-eyed. I just thought it was wonderful of him. He's up in Fort Dodge. He had been the mayor of Fort Dodge and was on the Court of Appeals for many, many years. A well-respected member of our judiciary. But it was just wonderful serving with people like him, the people of his character. Judge Habhab was a trusted friend. And before we leave Ashton wrote a poem about you that Judge Eisenhower recited at a meeting of the court right after the retention election, and we're going to try to get him to read the poem for the end of this interview. I can't even remember what it was. Well, no, you don't have to remember, but we'll see if we can enroll your son in this effort and try to get him to recite the poem. Thank you so much for doing this today. This has just been delightful. Thank you. We've had a great time with you, and a terrific career, which continues to this day. You ought to be proud of everything you've done. Oh, thank you very much, Dick. That's good. Your head in this, Mark. There you go. Okay, all right, there.
Okay.
Good morning, ladies and gentlemen. I'm Tom McNaught, Executive Director of the John F. Kennedy Library Foundation, and on behalf of Caroline Kennedy and our entire Board of Directors, it is my great pleasure to welcome you to the 2012 John F. Kennedy Profile and Courage Award ceremony. Please join in welcoming to the stage the recipients of this year's Profile and Courage Award, Marcia Turnus, David Baker, Michael Streit, and Robert Ford.
And my final task is to introduce the guiding light of the award committee and of this institution. What can I say about Caroline Kennedy? What I can say is that those people who say when they get a call from Caroline Kennedy that they say, Caroline Kennedy's calling? My God, this is just awesome. And they get a little bit scared. She is every bit as awesome as her reputation. She's also a lot more fun. She is a delight. She is the guiding light here. She is the one that makes this such a special, special place. So it's with my great honor to introduce our leader, Caroline Kennedy.
Thank you, Al. Thank you for not discussing baseball. Thank you. Good morning, everyone. This is a special day for the Kennedy Library, and I want to thank all of you for coming to share it with us, especially half the state of Iowa. It's wonderful to have all of you here to support our honorees and honor the memory of my father. All my life, people have told me that President Kennedy changed their lives. They decided to join the Peace Corps, or run for office, volunteer in the inner city or outer space, because he asked them to serve our country and do what they could to make this a more just and peaceful world. The generation that he inspired changed this country, fighting for civil rights, women's rights, human rights, and disarmament. And they passed that inspiration down to their children and grandchildren. As the first truly modern president, he redefined America's timeless values for a global audience and recognized the power of each individual to make a difference. As we mark the 50th anniversary of his presidency, his time is becoming part of history rather than living memory, that his words, his example, and his spirit remain as vital as ever. At a time when young people often feel disconnected from politics, we need to reach across the generations and recommit ourselves and our country to these ideals. One way that we connect past and present is through the Profile and Courage Award. By honoring individuals who act on principle without regard for personal consequence, we honor the quality that my father most admired in public life. This is a special year for the Profile and Courage Award. because we are fortunate to recognize 4 outstanding Americans who demonstrate how critically important it is that men and women of courage serve in all branches of government. The people we honor today say that they were surprised to learn that they had been chosen. They don't think they did anything special. They were just doing their job. But for public officials, just doing their job often demands a special kind of courage. Standing up for human rights requires courage. Serving the interests of all citizens, not just the majority, requires courage. As President Kennedy's ambassador to India, John Kenneth Galbraith, once observed, "It is far, far safer to be wrong with the majority than to be right alone." We owe a great debt to the 4 people we honor today for their courage and for the sacrifices that they and their families have made to secure a more just and peaceful future for all Americans. In 2009, in the landmark decision Varnum v. Bryan, the Iowa Supreme Court issued a unanimous decision holding that a statute limiting civil marriage to a union between a man and a woman violated the Equal Protection Clause of the Iowa State Constitution. Iowa Chief Justice Marcia Turnus and Justices David Baker and Michael Streit voted with their colleagues to make Iowa the 3rd state and the first Midwestern state to allow gay marriage. The eloquent opinion states, in part, "Civil marriage must be judged under our constitutional standards of equal protection and not under religious doctrines or the religious views of individuals. This approach does not disrespect or denigrate the religious views of many Iowans who may strongly believe in marriage as a dual-gender union, but considers, as we must, only the constitutional rights of all people, as expressed by the promise of equal protection for all. We are not permitted to do less and would damage our Constitution immeasurably by trying to do more. In the final analysis, we give respect to the views of all Iowans on the issue of same-sex marriage, religious or otherwise, by giving respect to our constitutional principles. These principles require that the state recognize both opposite-sex and same-sex civil marriage." The decision of the Iowa Supreme Court sparked a political backlash. Nationally financed opponents of same-sex marriage ran an expensive and divisive political campaign intended to intimidate judges and legislators who oppose their views, both in Iowa and beyond. Under Iowa's system, highly qualified judges are appointed by the governor and then subject to a retention vote every 8 years. The retention vote system is intended to provide a way to remove jurists who are unfit to serve, and the campaigns leading up to them have been characterized by the prevailing view that it is inappropriate, if not unethical, for sitting judges to engage in political electioneering. In November 2010, despite their long and distinguished service to the state of Iowa, Marcia Turnus, David Baker, and Michael Streit were ousted. They were the only 3 Supreme Court justices to stand for retention that year, and they are the only 3 judges in Iowa history to have been ousted in a routine retention vote. The justices were aware that they might pay a price even before they handed down their opinion, but they did not waver. In their decision, they wrote, "A statute inconsistent with the Iowa Constitution must be declared void, even though it may be supported by strong and deep-seated traditional beliefs and popular opinion." In 1963, as civil rights demonstrations throughout the South met with increasingly violent opposition, President Kennedy said, "We are confronted primarily with a moral issue. It is as old as the scriptures and as clear as the American Constitution. The heart of the question is whether all Americans are to be afforded equal rights and equal opportunities, and whether we are going to treat our fellow Americans as we want to be treated." Just as judges stood firm for civil rights 50 years ago, Marcia Turnus, David Baker, and Michael Streit, their colleagues on the Iowa Supreme Court, and dozens of other public servants across the country have put their own careers on the line to uphold the rule of law and extend the fundamental promise of equal rights. This award is usually given to elected officials in the legislative branch of government. But in honoring these 3 principal jurists, we seek to remind all Americans of the importance of an independent judiciary and its role in safeguarding our most fundamental rights. We are fortunate to have with us today 3 other Iowa Supreme Court justices who voted with our honorees. Justices David Wiggins and Mark Hecht are here today, along with current Chief Justice Mark Cady, who wrote the landmark opinion. I would like to ask them to stand now and be recognized. Now I'd like to ask former Iowa Supreme Court Justice Michael Streit to come forward and accept his award.
Thank you for having us here today on this very special day. I feel very honored and humbled by the Profiles in Courage Award. Honored because of what this award stands for and what President Kennedy believed. Principled governance for our country and its citizens. Humbled because we join award recipients who did their jobs with principle and in the national interest. It is very moving to be part of this award, an award that honors political courage, courage to challenge political leaders and interests. Our court will carry on, but only if we all step up with courage to say no to those special interests and moneyed interests. Our court followed the rule of law, strongly believing in our Constitution, which guarantees equality for all Iowa citizens. I am grateful for the role I played in this decision and for the award, for this award. Thank you to Carolyn and to the foundation and for this award. Thank you to everyone here today. Thank you for what you believe in. Thank you for the honor. Much of what this award stands for and what Caroline Kennedy and her family wished in establishing this award was suggested by Robert F. Kennedy when he spoke in Cape Town, South Africa in 1966, 2 years to the day before he won the California primary. He stated this: few people will have the greatness to bend history itself, but each of us can work to change a small portion of events, and in the total of all those acts will be written the history of this generation. It is from numberless diverse acts of courage and belief that human history is shaped. Each time a man stands up for an ideal, or acts to improve the lot of others, or strikes out against injustice, he sends forth a tiny ripple of hope. And crossing each other from a million different centers of energy and daring, those ripples build a current that can sweep down the mightiest walls of oppression and resistance. He went on to say, few are willing to brave the disapproval of their fellows, the censure of their colleagues, the wrath of society. Moral courage is a rarer commodity than bravery in battle or greater intelligence, yet it is the one essential, vital quality for those who seek to change a world that yields most painfully to change. The future does not belong to those who are content with today, apathetic towards common problems and their fellow man alike, timid and fearful in the face of new ideas and bold projects. Rather, it will belong to those who can blend vision, reason, and courage in a personal commitment to the ideals and great enterprises of American society. It was almost 30 years before apartheid ended in South Africa after that speech. Right after our court filed the marriage equality case, 5 days later, the court received a handwritten letter. This letter really brought home to me what we did in our decision was right. The author stated, after a few introductory remarks, too profane to read here, he said this: I defended the likes of you as an American soldier in World War II and Korea. I conclude I served the wrong side. Hitler treated queers the way they should be treated, in the gas chamber. You are bastards. The emotion revealed was breathtaking. We cannot change such raw and intense feeling with nuanced discussion. This brought home to me what the gay community and families with gay members struggle with every day. It also satisfied me that we were right to resist political and expedient solutions, to withstand the intimidation. People and forces exploited this fear, prejudice, and the paranoia reflected in the letter. They pressured our court to follow the will of the people, no matter how manipulated or orchestrated, no matter how it violates the basic human rights of being treated as equally as other citizens. Such forces must be challenged. My hope is that we will contribute a tiny ripple of hope, and that this ripple builds a current that can sweep away such prejudice. The Profiles in Courage Award is made here in this beautiful structure at the John F. Kennedy Presidential Library and Museum. The library was designed by I.M. Pei, the same designer of part of the Des Moines Art Center. Pei said this: "One has to persist. You have to identify the important things, press for them, and not give up." What our court did was to justly and honestly interpret the Iowa Constitution that guarantees equality for all. We did this as political forces, seen and unseen, swirled around us. We identified the important things: fair and impartial judging, equal protection for all, and press for them. Our acceptance of this award says that we will not give up. We will push forward. We will persist. Thank you.
This is Ashton Streit. I wrote this poem about my dad when I was about 11 after he was not retained in office. You make people laugh and smile. You like to tell stories. You like to have fun. You are the friend I aspire to be. You inspire me. You motivate me. You challenge me. You are the father I aspire to be. You are a role model. You mentor young lawyers. You encourage others. You are the teacher I aspire to be. You are intelligent. You say don't give up. You are positive thinking. You are the leader I aspire to be. You are brave and strong. You protect and defend people. You help others. You are the hero I aspire to be. You have pride and honor. You do what's right. You are caring and kind. You are the man I aspire to be. Thank you, Dad, for leading by example